Be ready. 5 seconds. Start. The High Court relied upon another judgment of this court in the case of State Bank of India versus D.C. Agarwal. Stop. In that matter, also the High Court had quashed the punishment imposed on the respondent, since the CBC report had not been furnished to him. Stop. In paragraph 5 of the judgment, this court observed as may be that the disciplinary authority has recorded its own findings, and it may be coincidental that reasoning and basis of returning the finding of guilt are same as in the CBC report, but it being a material obtained behind back of the respondent without his knowledge or supplying of any copy to him, the High Court, in our opinion, did not commit any error in quashing the order. Stop. Therefore, in the present case, the High Court set aside the punishment imposed on the respondent. Stop. It also issued a mandamus to the appellant bank to consider the respondent for promotion, which he had sought. Stop. Being aggrieved by that judgment and order, this appeal has been filed. Stop. Mr. Butt, learned senior counsel, appeared for the appellant, and Mr. Gupta, learned senior counsel, appeared for the respondent. Stop. It was submitted on behalf of the appellants that the High Court had interfering with the punishment, and in any case, directing consideration of the respondent for promotion. Stop. Mr. Butt, learned senior counsel for the appellant, submitted that the bank was required to refer the matter to the CBC, which is constituted under the Central Vigilance Commission Act, 2003. Stop. Regulation 19 of 1982 regulations framed thereunder makes it obligatory whenever there is a vigilance angle involved. Stop. This regulation reads: consultation with the Central Vigilance Commission. The bank shall consult that Central Vigilance Commission wherever necessary, in respect of all disciplinary cases having a vigilance angle. Stop. That apart, he submitted that the bank had arrived at its decision on its own, and not because of any dictate by the CBC. Stop. Charge number 1 was a serious charge. Stop. It was already proved in the departmental inquiry, and although it is true that at some stage the bank management thought that a lenient view may be taken, it specifically arrived at its own decision, as can be seen from the appellate order. Stop. In his submissions, there was no prejudice caused to the respondent by not making the report of the CBC available to him. Stop.